What's up, sheepdogs? Ryan here. In this training, we're going to discuss the Florida Castle Doctrine Law. We will discuss when it is legal to use deadly force and non-deadly force to protect yourself, your family, and your personal property. If you've lived in Florida for a while, you've probably heard of the Florida Castle Doctrine Law. The Castle Doctrine gives you the legal right to use or threaten the use of a firearm when you are located inside of your castle. This would include your residence, dwelling, or an occupied vehicle. The Castle Doctrine is a common law doctrine, stating that a person has no duty to retreat in his or her home or castle, and may use reasonable force, including deadly force, to defend his or her property, person, or someone else. This doctrine gives you two powerful presumptions. Under the Florida Castle Doctrine Law, you have the right to presume or assume two really important things. The first presumption is that you have the right to stand your ground, as outlined in Florida Statute 776.013. A person who is in a dwelling or residence in which the person has a right to be has no duty to retreat and has the right to stand his or her ground and use or threaten to use. Now, I'm not going to complete this sentence yet because I want to hold off and explain the second presumption, so we're going to come back to this a little bit later. The second presumption is that you have the right to believe that the attacker is planning to commit an unlawful act involving force or violence. This is outlined in Florida Statute 776.013, subsection 4. A person who unlawfully and by force enters or attempts to enter a person's dwelling, residence, or occupied vehicle is presumed to be doing so with the intent to commit an unlawful act involving force or violence. It's important to note that in order for the second presumption to be in effect, the attacker must be entering or attempting to enter unlawfully and by force to a dwelling, residence, or occupied vehicle. We're going to discuss what these terms mean in a later section. But first, let's discuss what can eliminate the presumptions granted to us under the law. According to Florida Statute 776.013, subsection 3, the presumptions granted under the law can be eliminated in four ways. The first way the presumptions can be eliminated is if the person who entered your dwelling, residence, or occupied vehicle has a legal right to be there. The person against whom the defensive force is used or threatened has the right to be in or is a lawful resident of the dwelling, residence, or vehicle, such as an owner, leasee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person. The second way the presumptions can be eliminated is if the person being removed is a child or grandchild and the person removing the child or grandchild has lawful custody. Here's what the law says. The person or persons sought to be removed is a child or grandchild, or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened. If Tiffany and I were ever to get separated, and I decided to swing by the house and pick up one or all of my children, Tiffany would not have a legal right to use or threaten the use of a gun because I have just as much legal right to take my children as she does. Now, obviously, this would only apply if we had joint custody and no restraining orders. The third way these presumptions can be eliminated is if the person who uses or threatens to use deadly force is engaging in criminal activity. Here's what the law says. Florida Statute 776.013, subsection 3, subsection C. The person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling, residence, or occupied vehicle to further a criminal activity. Obviously, if you're making meth in your garage, then you do not have a right to use or threaten the use of deadly force. The final way these presumptions can be eliminated is if the person against whom the defensive force was used was a law enforcement officer. The person against whom the defensive force is used or threatened is a law enforcement officer, as defined in Florida Statute 943.10, subsection 14. who enters or attempts to enter a dwelling, residence, or occupied vehicle in the performance of his or her official duties, and the officer identified himself or herself in accordance with any applicable law, or the person using or threatening to use force knew or reasonably should have known that the person entering or attempting to enter was a law enforcement officer. It should go without saying, but you do not have a right to use a firearm against a law enforcement officer who is in the performance of their legal duties.